Welcome to today's program titled Effective Strategies for Government Software License Negotiations. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn the program over to our first speaker, Teddy Arnold. Teddy, you may begin.
Good afternoon, everyone. Thanks for joining us. My name is Teddy Arnold. I'm a partner in the Government Contracts Group at Seyfarth Shaw. With me is my partner, Ken Wilton, who is a partner in our IP group, our intellectual property group. Ken is in California, I'm in DC, and we are delighted that you're joining us for what is part one of a 30-minute micro webinar series, the title of which is Winning Combinations, where essentially we team up with other practice groups to discuss legal issues for government contractors that cross into multiple practice areas. And so our thought is that if your legal issues don't fit squarely into one practice group, the content we provide shouldn't either. So before we jump in, I'll just make a quick plug for the upcoming topics. They're all 30 minutes, so they're not designed to crush your lunch hour. But we're going to be covering sustainable procurement in October, M&A in November, and labor issues in December. And then we'll have some more into next year. And so kicking off part one, we've got a great example of the intersection between government contracts law and IP law, which is software licensing with the federal government. And Ken and I have worked together where these issues have intersected over the years. And so if you go to the next slide, Sadie, the agenda is we're going to do an overview of government policy and acquisition vehicles related to software, an overview of software licensing generally, license provisions that you should be considering in negotiations, both commercial terms and terms that otherwise conflict with federal law. And then if we have time, we'll cover some of the recent disputes that have come out that highlight some of the best practices in negotiation. So let's dive right into it. I think the goal here is to sort of help set your expectations about what the government can and cannot agree to in a software license, as well as highlighting what terms are fair game for negotiations so that you can properly adjust as needed. And so the DoD in particular, they're a major player in software acquisition. They have regulations and policies that govern procurement of commercial and non-commercial software, non-commercial being wholly or partially developed at government expense. And these policies and these procedures sort of address what the government's rights are and what is developed. We'll highlight the regulations in a couple of slides. But first, I want to kind of just give an overview of what sort of software policies have been out there in recent years. Starting back in January of 2022, when the DoD reissued and updated its acquisition policies, which emphasize speed and agility in the acquisition process. And that's a big, big theme right now when you hear about software policy, which is this idea that it's got to be quick, it's got to be agile. Agile actually being a term of art, which I'll talk about in a minute. But the updated instruction established what's called the adaptive acquisition framework, which has these 6 acquisition pathways, and they're designed to essentially deliver solutions to government end users quickly. And so one of those 6 pathways is a software acquisition pathway, which is designed to do just that, get software to the government expeditiously, whether it's commercial or whether it's non-commercial. And an important nuance there is, even if something it was built or developed with government funding, it could still qualify as commercial under the rules, which would then impact the license rights the government is entitled to and your subsequent negotiation. And so in February of 2022, DoD issued some additional guidance to its adaptive acquisition framework. And this specifically was really a guidebook. It sort of looked at, it considered costs in licensing and described different licensing models that could actually increase costs, including a specific section that governs the unique requirements of acquiring cloud services, which is obviously a huge topic these days. And then in March of last year, DoD issued what's called the DoD Software Modernization implementation plan. And this was, it includes tasks for increasing the adoption of these enterprise approved clouds to increase agile acquisition, promote this software modernization across all the acquisition vehicles. And so you hear this term agile a lot. Let's talk about it for a second. Essentially, DoD requires that its programs that are on this software pathway to be tailored to support what's called agile development, which is really just making sure the program is streamlined and it can help ensure the programs iteratively develop software aligned with the end user's needs. And so a big example of this, what's not really agile, are big weapons programs. They develop software on different pathways that don't incorporate these agile concepts. And so the idea is that by not using agile concepts, these programs risk developing capabilities that may not reflect the changing needs of the user or other threats. So you just think of agile as sort of getting the government software that's quickly, that you're able to collaborate with the customer and that they can adapt sort of on the fly. That's sort of the idea behind it. The Army has a new software directive, I should mention, because this recently came out this year, a couple of months ago, and it's been in the news recently, as early as this morning. Essentially, they're issuing this big IDIQ for modern software development, and there's a lot of engagement right now with industry as to what the contract types are going to look like. They're going to be determined at the task order level, and there's a lot of talk about whether they're going to be, sort of fixed price contracts or cost plus, and there's a lot of pushback on the idea that they be cost plus. But in any event, the Army is transitioning all of its programs to this agile processes. Acquisition vehicles. Oh, by the way, yeah, we're still on the last slide. So acquisition vehicles. I'll just highlight that the DoD has something called the Enterprise Software Initiative. It's designed to give DoD customers discounts based on GSA schedule pricing through the negotiation of blanket purchase agreements. And so if you're reading the news, there's a bunch of these ordering agreements out there. It covers software, hardware, IT services, things like that. And I know recently the Navy has been awarding a bunch of these contracts to provide software licenses to resellers, primarily using the GSA schedules contracts. You can go to the next slide, Sadie. So this is just a brief overview. I found this in a GAO report of what the purchasing activity has been. So you can see who the big players are. Probably no surprise when you look at this, that the lion's share of software license purchasing is done among the big companies like Microsoft, Adobe, Salesforce, IBM, et cetera. You go to the next slide. So commercial, what is commercial software? It's software that's ready-made and available to the public. It's defined specifically in the FAR. It's defined as computer software that's a commercial product or a commercial service. And if you go to that definition, many of you probably know what that is. That means it's a product that's customarily used by the general public and has been sold to the public or offered for sale to the public, in large part, with a few other categories as well. But that's generally the definition. And then many of those software products are further defined as commercially off the shelf or COTS, meaning that the software is sold in substantial quantities in the commercial marketplace, largely unchanged. This is contrasted with what you hear about as open source software. Essentially, all OSS is commercial computer software as defined in the law and the DFARS. That's relatively unchanged. It's almost always going to be COTS as long as there is at least one non-governmental use and it's licensed to the public. If you go to the next slide. Okay, so this is you, Ken.
Thanks, Teddy. Good transition. I figured I'd level set us a little bit on just the general terms of a software license and how we look at them, because coming from the IP side instead of the government contract side, we look at it a little bit differently, and it's that intersection where it gets kind of tricky. So I figured it made sense to talk about a little bit how we should be looking at software licenses in general. The primary takeaway I would have is software is protected by copyright, and that bundle of rights under copyright can be licensed in any way you want. And each one of them is separately or collectively licensed. So when you're dealing with a software license, a couple of questions arise. When are they required? Pretty much everywhere, every time you have a third party using your software. But the software can be accessed in very different ways, which requires different licenses. So if it's installed on a computer at the customer's site, that's one sort of license. Accessed on a central server at the site, that's another one. Or accessed via the web, which is software as a service, which I know everybody's heard of. They usually and almost always have some sort of limited scope of use. And those limitations can be anything we can imagine. And we'll talk about some of those limitations as we go through this short overview right now. Oftentimes, especially with the government, you'll find bundles of licenses put together. A lot of resellers are the direct contractors with the government, and they are, so you don't have the producer of the software as the contractor, but you have a reseller that has several on their shelf, if you will, following the COTS model. The trick with a software license is to anticipate all areas of dispute, which of course is impossible because folks are pretty clever in finding disputes, but we do our best. And so I thought I'd touch on some of the overall things to be looking at. So let's go to the next slide. You have several sort of basic types of licenses. One relates to the term or the duration of the license. You know, a perpetual license, which you find in a lot of the commercial software that we all use on our PCs, is simply a license that is in perpetuity. It may not include upgrades, it may not include maintenance or anything like that, but it's a perpetual license. There are subscription and term licenses which do include maintenance. Those are usually with regard to somewhat more complex software. And those are areas where, particularly when dealing with the government, those are very important because the government does not want to be working on, Word 2.0. And so, as a consequence, those are almost always included in some fashion with dealing with a government contract for software. When you look at the use limitations, there are a bunch of ways of limiting the use. It can be by workstation, it can be by person, it can be by user. It could be by number of concurrent users. So you have 20 licenses that can be used by any 20 people at the same time, and you don't identify those people. You could have it per person, and you identify those folks. You can have software licensed on a server to a particular enterprise, for example, or a site if you have multiple sites, locations, physical locations where the software might be used. You can put all of those types of limitations into your agreement, and those need to be figured out upfront. It's all part of the negotiation process, exactly how you're going to do this. Sometimes they're bundled with other services. And at the bottom here of this slide, you have software as a service, platform as a service, infrastructure as a service. So if you look at, for example, software as a service, the back end is controlled by the licensor because it's on the web. So they're actually handling, hosting the software, updating the software, et cetera. Customer just needs to log in behind a password wall and use the software, which is a lot easier for certain organizations than if you actually have to have your IT staff updating and doing everything else. Let's move on to the next slide, please. Fees. Fees, of course, are the core of any kind of license scheme. Usually they are pretty straightforward, but there are different models in terms of paying. The standard software license started back in the days of mainframes where you get a license to the software and you get maintenance, which is a percentage of the license fee, of the annual license fee. Maintenance includes upgrades, bug fixes, support, and levels of support, and you can have all of those tailored into your software license. And usually, especially with the government, because of where the expertise lies, it's going to be in there, and you're going to have some support requirements, and all of that usually comes under that rubric of maintenance. And there is a fee, and the beauty of that from a software vendor perspective is that you have that stream of income over time, as opposed to just an upfront license fee. So let's move on to the next slide, please. So here's some, I put together some basic terms, actually, no.
Yeah, this is
now
me.
We're moving on to you.
Right, so I'll set the stage for how we're gonna get to the terms and conditions of your license. Before we do, sort of what the government can and cannot agree to is critical. And so government license rights. So commercial companies generally fear the government is going to obtain extensive rights in its IP. And so the goal of the government in that instance to entice commercial buyers is to be on the same footing with as would any other commercial entity in like an arm's length transaction. So to that end, the FAR and the DFARS require agencies to acquire commercial software through licenses that are customarily provided to the public, to the extent the terms and conditions are consistent with federal law and the federal government's needs. And so it's that category of what is consistent with federal law that is the big one. And then there's going to be some other unique requirements the government may be able to negotiate for that are not customarily available to the public. Neither the FAR nor the DFARS provide required licensing terms and conditions for restricted rights commercial computer software. So essentially that means it's a fair game negotiation, and agencies are encouraged to negotiate commercial license agreements as necessary, subject to certain restrictions. And then the license will really specify what the government's legal rights to use the software are in accordance with the terms that are agreed to with the copyright owner. And so one other principle that a lot of companies ask about is, am I giving up, my ability to still own the software? And the answer is no. It's a common theme in government contracts IP that the government only gets license rights. You retain ownership. You, the copyright owner, retain ownership of that software, of that IP that you developed. And the government's just going to get a license, and what level of license is really dictated by whether it's commercial or non-commercial. Here we're talking about commercial, and so it's going to be dictated by the license agreement. Go to the next slide. And so you hear the term EULAs, end user license agreements. These are really just commercial software license agreements. The end user can be an organization or it can be a person. There can be different forms. You can have non-negotiated ones. It can just be the standalone document that comes with the software. It can be a click wrap agreement, which is pretty common. That's where the user has to agree to the terms and conditions before using it. Or it's a shrink wrap agreement, which is less common, but that's where a user's installation or opening of the software indicates agreement to the terms and conditions. And then you've got negotiated, which is really what we're going to get into. You've got negotiated terms, which is just like an arm's length negotiation. And of course, keeping in mind, the government can't agree to things that are inconsistent with federal procurement law or that don't meet its needs. And back over to you, Ken.
Okay, let's go to the next slide, please. And another one. So I'm going to touch on some of at a high level, what terms should be in a license, a negotiated license. And most of the folks on this webinar are aware of them, but I thought it'd be worth touching. And then Teddy's going to jump into what can't be done, even though we're used to doing it in a commercial environment. So the scope of the license is a very important element in the sense that you need to know exactly what it is that you're licensing, what software, what version, what release, upgrades, documentation, same thing, because documentation usually is upgraded and changed over time. There's an important element of all licenses now, and that is how open source software is incorporated. Because open source software is licensed under a different scheme, if you will, than the license that is being granted to either the government or some other end user. And so what we end up with is sort of an admixture of the software that is developed by the company, which is licensed in one fashion, and the open source software, the various components that are added to that or used in connection with that, which are licensed under a different scheme. So one needs to be aware of it. Most of the time, these licenses now include disclosures of what open source software is included and which of the licenses, like the Apache or whatever, is being used, so that the end user has an idea of what it can and cannot do. Usually there are indemnification representations by virtue of the fact that since it's a copyright issue that we're dealing with, there could be issues of infringement if somehow the code infringes somebody else's code. Move to the next slide, please. Parties and authorized users. This one gets really kind of fun when dealing with the government. In the commercial sense, it's usually pretty straightforward. The licensor is the person who has the right to the license. Licensee is simply the corporation or entity or person who is taking the license. The government is a little bit tricky because you sometimes have fulfillment groups that are acting on behalf of multiple agencies. And now you have to identify who of those agencies, particularly if you have a seat license or a user license where they have X number of concurrent users, those can be spread over different agencies that are working under the one fulfillment office. And those need to be identified with some particularity so that you don't run into the problem where the software is just being used by everybody who wants to use it. Going back to what we talked about a little bit with enterprise, site, and the seat license, all of those can be built into your agreement so that you are identifying exactly who is going to be using the software and who is prohibited from using the software. So consideration that is, like Teddy and I worked on a number of cases now where it becomes a primary consideration because of the flexibility that the government needs to use the software versus what the licensor might want to limit. So next slide, please. What rights are granted? Usually, copyright has this bundle of rights. What usually are implicated by software are the right to reproduce or copy, modify, distribute, and in certain cases, publicly display when you have sort of the output being displayed somewhere. All of those should be taken into consideration when you're negotiating one of these licenses, and that requires a back and forth between you and the government procurement office in terms of figuring out what is actually going to be done with the software. Most commercial licenses don't allow modification. If you buy a copy of Word, you got it, you don't get the source code, you can't modify it, there's nothing you can do with it. Sometimes the government needs those modifications in order for the software to be interoperable with other software. And so you have to deal with that issue too, which includes development issues as well as ownership issues and license issues after that. Let's go on to the next slide, please. Other common terms, obviously the scope of use, the term is an automatic renewal or not automatic renewal. In other words, does it just renew every year after year with the payment of a certain price due? Choice of law provisions. Most software licenses you will see, however they're entered into, have a choice of law, usually where the headquarters of the developer is located, and venue provisions. Are there indemnity? Indemnity from infringement by the licensor indemnifies the licensee, or the reverse. I mean, do you have the licensee in some fashion indemnifying the licensor in case it does something that modifies the software or goes in a different direction? Is there a right to sublicense or assign? What if in normal circumstances, commercial entities change hands all the time, and so you will find situations where you need to have that assignability and maybe even the sublicenseability. Confidentiality, usually only on a negotiated license, since the commercially off-the-shelf software is everybody has the same license. If you're negotiating one, do you have a confidentiality provision in it so that the next entity that you're dealing with doesn't know the terms of the first one? An integration clause, which is a common theme in most contract formation. You say that your contract is integrated and can't be modified absent written agreement by the parties. Territorial restrictions, where you might have, the software can only be used in X state or X country or whatever it may be. And finally, the last one is common, at least in most development contracts, where you have escrow of the source code in the event of the bankruptcy of the licensor or the developer. So all of these are common terms that you'll see in a commercial license. And I'm going to flip it back to Teddy to talk about what you can't put into a government license.
Okay, you go to the next slide. All right, great. So when you get to the point of you are an offeror and you're submitting your commercial license to the government, this is the applicable framework. So the procurement is, for its commercial procurement, it's going to incorporate a FAR clause 52.212-4, which is contract terms and conditions for commercial products and commercial services into the awarded contract. Why is that significant? It's significant because that will designate the order of precedence for inconsistencies among all of the contract documents. And so you'll see the hierarchy up there in the screen, which is in subsection S. And you'll see if you go down from top to bottom, you'll see that there are specific paragraphs of that clause, the terms and conditions clause, which are higher in order. And then you get down number 4 here is addenda to the solicitation that includes the licensing agreements, that includes your EULA. And then you keep going and you'll see that the EULA ostensibly takes precedent over other paragraphs of the clause. And that becomes really problematic. And if you go to the next slide, because the license agreement has this higher order of precedence, in terms of how the contract's going to be applied. The government is going to be on to, okay, what terms are in your license that I'm not able to agree to? And so the way it would work is that agency counsel is going to review the license to ensure compliance with federal law. They're likely going to ask for it in a Word editable format so they can make track changes. And they may enter into a negotiation with the contractor directly. This can occur at the task order level, or if it's just the award of a new contract. And so if you go to the next slide, Sadie, what are the clauses that you need to be mindful of? All right, so the automatic renewal. And some of these are going to be it's absolutely no go. Some are a little more nuanced where you may be able to negotiate something around it, but these are the rules you need to be aware of. Automatic renewal. So you can't have an automatic renewal in a EULA. And the reason is because an automatic renewal would presumably violate the Competition and Contracting Act, which requires the government to obtain full and open competition through competitive procedures. And if you have a clause that says your license automatically renews, this is going to be seen as a new contract that did not go through full and open competition. And it also might likely violate the Anti-Deficiency Act and a few other sections of the FAR. Choice of law and forum, these are almost commonly drafted together in a EULA, in a license. These generally conflict with the government's sovereign immunity. So your typical choice of law clause says we agree in advance of the laws of a particular jurisdiction. Usually it's state law that govern the license. However, this conflicts with the government's waiver of sovereign immunity. The government says you can only sue us for a violation of this contract or this license through the Tucker Act, the Federal Tort Claims Act, if it's some kind of bodily injury or personal injury, or the Contract Disputes Act. And so the agency itself can't waive the federal government's sovereign immunity. And so your clause is going to need to say it's governed by the CDA or the FTCA. Government indemnity, an open-ended indemnity clause, this is where the government's agreeing to compensate the other party, the indemnified party, for costs and expenses that relate to a third-party claim. This will violate the Anti-Deficiency Act because with an open-ended indemnity clause, the amount that the government is potentially on the hook for can't be ascertained when the agreement is entered into, and thus it's unlimited, and this could exceed the agency's appropriations. And so agency counsel is going to ask you to delete that. You could negotiate for some kind of capped indemnity, which will sort of set out a maximum obligation, but the contracting officer's got to go and make sure obligated funds are set aside to cover that cap. So something to keep in mind. If you go to the next slide. So contractor indemnity, this is an indemnity clause that requires the contractor to defend the government against third-party infringement claims. Not gonna fly because the government can't relinquish its defense and litigation to anyone other than the Department of Justice. And so that clause is likely going to be deleted unless the agency has a reason for wanting to have the contractor indemnify it against third-party claims. And if the agency wants that indemnity, the clause is going to have to make clear that DOJ is going to represent the government in federal court. Assignment, essentially there's the Anti-Assignment Act. It says that, or any clause that would allow the contractor to assign the license to a third party would violate the Anti-Assignment Act, which says that you can't assign it without government approval. And so the clause would need to address that if in fact that, there needs to be an assignment or you want to reserve the right to an assignment, the government's going to have to be able to follow the statutory protocols to give approval in that instance. Confidentiality, these clauses tend to conflict with FOIA. The agencies have an obligation to release their contracts under FOIA, save for certain exemptions that cause competitive harm to a contractor, but substantial portions of the contracts are often subject to release with the exemption covered information that's redacted. So probably you're going to have to remove that unless you can draft a compliant clause. It may not be, there may be nothing in your EULA that is sensitive information, or you may be able to remove that because you may not be worried about the agreement itself being released to the public, but just something to consider. Integration clause, this says that the license agreement is the entire agreement between the parties and takes precedence over any associated contract documents. I think from the order of precedence clause, you saw that that's not possible because there's a number of documents that will constitute the entire contract. And so the license agreement can't be the entire agreement. It's got to take into account all the entire contract and all the associated documents. We go to the next slide, and I think this will be last slide because we're butting up against the time here. So these are some other provisions that will conflict with federal law. There's a late payment penalty. If there's a late payment penalty, you have to consider the Prompt Payment Act, which says the government's got to pay contractors within 30 days. And so, you know, if there's something that says 15 days, that's inconsistent. So that would conflict. Taxes, license agreements occasionally contain clauses that require government to pay for taxes that are associated with the purchase of software. This also violates sovereign immunity, and the Supreme Court, in any event, has already ruled on this and said that the government is constitutionally immune from paying any buyer state taxes. It can only agree to state taxes where the incidence of tax only falls on the vendor. Termination, you can't have a clause in there that allows the contractor to unilaterally terminate the contract, because that would violate the CDA. The government retains the right to unilaterally terminate, and then or to terminate for convenience, I should say. And then unilateral termination, this type of clause says that the contractor occasionally makes unilateral changes or updates to the agreement. This conflicts with the FAR. It potentially violates CICA, and the FAR provides that only contracting officers can modify the contract on the government's behalf. And so the government won't be able to agree to allow a contractor to make unilateral changes to the EULA in any event. So we are out of time. I kind of knew this would happen. So there are, I'll just highlight real quick, say if you go back, there's a number of disputes that are out there that are really recent, that are all really interesting. They highlight a bunch of different lessons along these lines. The idea of the government not being able to keep track of the software licenses that it's purchasing is a big theme. And so obviously something to think about in your negotiations, which is how are you tracking how the government is using it? Are you, the contractor, going to track it? Is the government, are you going to rely on the government to track it? And how are you, how are you accounting for that in your license? So definitely check those out. I mean, we could probably do a whole nother segment just on those cases. So with that, I think thanks for attending. This was a micro webinar. It was a lot of ground to cover. We are happy to answer any questions on anything we said that we really couldn't do a deeper dive on. So feel free to reach out to either myself or to Ken.
Thank you very much.